What is going on, sir? You kind of allude to that you have the children, but I don't know why or how or what's going on.
So um it's 50-50
Right,
as of now. But
right.
the reason why I asked for the hearing was because at the time Miss Belcher was in the process of being kicked out of her boyfriend's house,
Okay.
and technically she was homeless at that time.
All right.
And so she was asking me to keep the kids
Right.
during that time frame.
Okay. So
But
that was the cause of you to have. Okay. Does she have housing now?
yes, at the moment she
Okay.
said it's temporary, but yes, she
Okay.
does.
Alrighty, so it's back to week on, week off. So that you understand, if something like this happens, there is case law that deals with this. It's called Thoreau versus Dorr. It basically says if somebody gets, thrown into a situation where it's untenable, they can ask the other parent to please take the kids for a few weeks while I settle this and get stabilized. If it
Correct.
takes less than a year to stabilize, it goes back to the week on, week off.
Okay.
So what the law is trying to encourage is people not to say, "Hey, look, throw up my hands. I had this awful thing happen, but it'll be settled in a month or in about 6 weeks or so." And then the other party comes running in and tries to wrest custody because then nobody's going to want to give custody to the other side because they think
Correct.
it's going to wind up into a custody battle. So that's
Hmm.
why the law does this, so that you understand. You guys acted perfectly within the law to say, "Look, you take them for a few weeks, watch over them a little bit more, and then go back to the normal once everything settles." All
Correct.
right. If it does become a longer term thing, then please do file the motion. But give me a little bit more background as to why you're having the kids more. You just kind of
Correct.
said I'm having the kids more, and I had no idea. I've got a few cases this morning where Child Protective Services is involved. So
Correct.
there's all kinds of reasons this stuff happens. But if it's back to normal, then at this point your motion's denied without prejudice, and continue to take care of the kids on the week on week off basis.
Okay. Yeah,
All
and like I
righty.
said, yeah,
Oh
that's
no,
that's what it
you
was.
you you did okay. You did
Right.
fine.
Yeah, because like I said,
Yeah,
I just wanted to
yeah. Just
go
in
the right
case,
way.
yeah, just in case you did everything okay. You didn't do anything wrong. It's just that the court would say that once the situation's settled and reset, then we keep the week on week off, and the motion is denied without prejudice currently. Ma'am, if you
Right.
continue to be homeless, he may file a motion in the future to say, look, the kids can't handle, this back and forth and unstabilization. So that's also on, so take care of yourselves, take care of the kids. But it sounds like at this point, everything's back to normal. So have
Yeah.
a good morning. Take care. It's nice to meet both of you. Stay safe.
Yeah. You too.
Sir,
Yeah.
if it's okay to speak, he only had the kids for a week.
I wasn't going to get into because since I'm denying the motion, I was,
Um,
I just wanted to know what
I'm sorry.
caused it. You were getting kicked out of your house. It was an
and I
unfortunate situation.
was trying to put,
You've stabilized, and therefore everything goes back to normal.
and I even have a job now, sir, and I'm on my feet, and I'm just waiting for my first paycheck to go get my license and everything else. I already got my permit. I've already got a home situated. I'm just waiting for the money to come in to even get it all situated. That's where I'm at right now. I get paid next.
I'm presuming both of you are very good parents, and sometimes situations happen, and sometimes life happens. All right.
Then
Good luck
see,
to
now
both of you.
I get custody.
Thank,
Thank you.
Take care of the kids.
yeah.
Nothing changes. Good luck. Nice to meet you.
Yeah. Nice to meet you too.
Kershaw versus Waters.
Yes, I know. I'm trying to find the file. I've got the motion is actually almost as thick as the file.
Oh. Um,
So
oh, there he is.
yeah, the motion is this thick.
Oh, wow.
I have a feeling I know what's going on, and it's going to be interesting.
Hello.
Good morning, Mr. Waters. Welcome.
Good
Ms.
morning.
Kershaw. Ms. Kershaw, welcome. It's good to see you again. Hope everything's going well.
It's going pretty good.
Yeah, you didn't show up did you show up? I don't think you showed up the last hearing, Mr. Waters. We just had one a few weeks ago, but it didn't really have much to do with you. It had to do with some unfortunate situations with court filings and stuff. In
Okay.
any event, we're here in the matter of Kershaw versus Waters. From what I can tell of your filing, sir, because I mean it's thick, but it's all over the board.
Yep.
I take it the child is with Miss Kershaw right now.
Yep. I haven't seen
Yes,
my
sir.
daughter all summer
Okay,
long.
okay, Miss Kershaw, in what aspect and what auspices do you maintain custody of the child? Why do you have this kid? And she froze. Because you, from what I can tell, maintain sole legal and sole physical custody of this child.
I have since 2018, correct?
Yes, I know. I've read the file. The file gave
And,
me more information than your filing. Your filing just needed to contain a little bit more concise of the point of what happened and why the child went over to mom's. That's kind of, I pieced it together. I think it's a Child Protective Services case that got involved, and then you were not substantiated.
Yeah, well, she went to her mother's for the weekend and then Mother's Day weekend, which obviously she has parenting time with her on that weekend.
Right.
And she was supposed to be back Monday, and we let her stay till Tuesday
Right.
or Wednesday.
Okay. Again, Ms. Kershaw, now that you're unfrozen, the question stands. Can you hear me still?
Yes, I can hear you.
On what authority and what auspices are you maintaining custody of this child?
She's refusing to go back to her dad's. And when I had contacted the law enforcement, I've contacted CPS because I didn't know what to do in this case because I can't physically make her
Well,
go to her.
Child Protective Services unsubstantiated whatever allegedly happened. So they said nothing happened. He has sole legal and sole physical custody at this point.
I understand that. But I can't make her physically go back. She won't get out of the car.
Well,
she won't go home.
You might want to tell her it's a current court order that she follows. If she does not, Mr. Waters has the right to apply for parental kidnapping charges against you.
Well, I'm not holding her at her will, and if she says that if she goes home, then she's just gonna run away, and I'd rather not have her on the streets until we could figure out an agreement. I get that.
And Mr. Kershaw, Mr. Waters, why would she not want to return to your home?
I have no idea. See, came out and they did their investigation on the accusations that were said by Miss Kershaw and my daughter, and we've all been cleared. So,
have you talked with her since?
Who, Madeline?
Yes.
I've talked to her a few times. Yes.
And what is she saying? Why is she telling you she won't come back?
She hasn't said that she won't come back at all to me.
I suggest you give her a call. At this point in time, I'm going to enforce the court orders absent any motion otherwise to change custody, which I do not have before me. I don't have a motion to change. I don't have a motion to change custody or parenting time or anything. I have to enforce the orders as they currently are, which is he has sole legal and sole physical custody. If she gets harmed, you have no ability to make a decision at the hospital. Ma'am, he has sole legal custody, so you don't even have authority making.
That, and school's starting soon, so
yeah, and she's got to get
her enrolled in school.
75 days of school last year.
She has MRSA infection.
No, she was never tested positive for it. She never had no source.
She has a doctor's note that said she has MRSA.
Okay, well, but that is not a lab tested result, Brandon. You can't just look.
Who else would have gotten a test? I don't have any of this before me.
In my house,
please don't talk over one another.
I didn't know about this court hearing. They never served me my court papers. His wife had said something to Madeline about it, and I had called the courthouse.
All right. Right now, I am granting an order to enforce the current parenting time, and the police will assist if necessary. Most of the time, Mr. Waters, so that you understand, they will not do much to place a child in a car.
Yep.
But this might give the child an important. I suggest you speak with the child so that that's not necessary, both of you.
Yep.
If there is a motion in the future to change custody or parenting time, this court will address it appropriately, but with no indication about what's going on other than, like I said, I had to piece it together. No offense, Mr. Waters, but your motion was all over the board.
Yep.
I mean, you threw the kitchen sink in, but you know, I tried to read about the rest of the house,
I have a lot of paperwork on everything.
Yeah, but you just kind of threw it together and stapled it, and basically I tried to figure it out. All I can piece together is that CPS was involved. The child went over to her house during some investigation. The investigation puttered out, and it showed nothing. And now the child is obviously refusing to return. But ma'am, again, there is no legal authority for you to hold this child. The child needs to go back to the school the child will be at. And if somebody wants to file a motion in the future to change custody, we'll address it at that point in time. But I need information in a little bit more succinct manner and what is going on than me having to piece together. What we're really here for is return of the child and enforcement of the current court order.
Yeah, and I can get
more pieces to it if I was able to respond to the motion.
Well, maybe you file a motion in the future. Maybe you file a motion in the future, Ms. Kershaw. But right now, I have to enforce the current court order, which is what I will do.
regardless of what's going on in Mr. Waters' home?
Well, bottom line, I don't know what's going on. I have CPS who investigated Mr. Waters' home and said nothing's wrong with his home.
Okay, well, they did have an open case for a while and had to make
It's
a safety
closed.
plan.
They closed it. They closed it at the end of June.
They still had an open case
No.
because they found
June.
minor things wrong. And
I've read the one of the things that was in the thing, although some of the pages were upside down. In reading the CPS report, they found nothing. They did not substantiate anything, and they did it on June 28th. That case has been closed. Once the case is closed, custody goes back to the way it was. Okay. So I've had CPS investigate, and they have the lowest burden in the law. If they think there is a problem, really, again, you're going to talk all over me. Okay. All right. I'm enforcing the order. Have a good morning, ladies and gentlemen.
Yep. Thank you. Good. Thanks. When does she need to be home by?
You need to follow the court order. If it's your weekend, it's your weekend. But if it's not your weekend, now.
It's not my weekend, so he can.
Okay. He needs to go come get her. Yes.
I'll go
and
get her
then you blame me. It's the court enforcing its current court order.
So how does that work when I have a PPO order against her and
I saw that you have a PPO and no contact. What do you normally do with pickup and drop offs? She obviously has parenting time.
I just got the PPO order before when all this was going on.
Normally, enforcement of a parenting time order does not violate a personal protection order. This child is old. This child is old enough to walk from a house to a car.
Correct.
He's not old enough to separate our issues from co-parenting to his own personal issues.
All right.
I will be on my way to go get.
Can I request a front of the court investigation?
You need to file the appropriate paperwork to do so. Like I said, the only thing I'm here on, and that I had to piece together, was enforcement of the current court order, because the filing that I had was all over the board. So I had to piece together what might have even happened, because it's not straightforward. If you want a custody evaluation, you have to file the appropriate form of paperwork to have custody. All we're here on right now, and I kind of figured that's the way this was going to go, was that you two were going to throw stuff at me during the hearing that the court doesn't even know about.
Well, I didn't get a chance to respond because I was never. How can I get his PPO order sent to my apartment, but I never got the copy of this motion? Like, what would have happened?
Oh my God.
She never said anything to Madeline about it. Like, I would have missed it. And like, where did you guys send my papers? And I kindly asked his wife that, and she won't respond.
What's your address?
You know my address.
Hold it, guys.
Is
the address on 6th?
No, I updated all my information online because I decided to move back to Kentwood. It was a better opportunity. I updated my information online.
Okay, well, this was your.
Been here.
What online did you update it with?
The postal office in the front of the court, and I even wrote a letter.
Okay. Well, we're gonna go off air so that you can give him your current address so that he knows. One, Mr. Richardson, you have objected to this hearing. I mean, you objected to the front of the court recommendation. You have every right.
Hello, can you hear me?
Yep. I take it the minor child is with you this morning?
Yes, my son Timothy. Sorry.
Okay.
It's my other kid.
Oh, it's your other son. Okay.
Yeah.
All right. Well, bottom line, we've had this was sent to the front of the court for assistance in trying to get you guys a final order. Both of you have received the recommendation. Mr. Richardson, you have objected to that. The next step in this is that we have a court hearing.
Okay.
All right. The court hearing, unfortunately, you will be treated as attorneys. Luckily, about 80% of these things get vetted out by the front of the court. 10 to 15% come back to me with an objection. But the reason that we go through all this is because the front of the court can hear evidence that I may not be able to hear. You two are not represented by attorneys. You don't know the process. But unfortunately, when we get to the next step, you are treated as attorneys. So I'm granting you that hearing. At that hearing, each of you will be given an opening statement, and then you will have to present witnesses. You may call yourself as a witness. You may call each other as a witness. I'm assuming somebody may call the front of the court as a witness. If the witness that you wish to call does not want to come, you can go to the Legal Assistance Center. They will assist you in getting a subpoena to have that witness appear for court. Okay? But evidence only comes to the court through a witness on the witness stand. In other words, you don't send me a bunch of papers and I read them. That's not going to happen. What each of you would do, depending upon how this goes, if it's in person, you bring the evidence with you to court, but you send the other side copies of it before court, like 1 week before court. You send them what you're going to present at court. We don't do surprises in court anymore. Everybody knows what's going to happen. Okay. If we do it by Zoom, then you need to send it to the court a week ahead of time. Again, the court will not read it until you actually present it through a witness on the witness stand. The witness is under oath. The witness will be presented the exhibit. It'll be marked as an exhibit. The witness will describe what exhibit they're discussing. We will talk about it. It can be cross-examined upon. Then the court will enter it as evidence. Okay. This is a process. What I tend to tell people is if you walk into an operating room and you're going to remove a splinter from your finger, you might be able to do that easy. But if you're going to be doing abdominal surgery, you might want to have somebody there that knows what the heck they're doing. Because as just happened about 3 weeks ago, they showed up. I gave them this same speech. I asked them for their opening statement. They did not have one. I asked them to call their first witness. They didn't have any of those. Guess what happened? Absolutely nothing, because I couldn't do a darn thing. The court has to have evidence. About 8 months ago, somebody properly sent me 18 proposed exhibits and only entered 4 of them during the hearing, and then wondered why I didn't consider the other 14 in making my decision. They weren't before the court. Okay, so you're swimming in deep waters. Now, the question that I have for each of you is, do you have any questions? Let's see, Shayna, we'll go with you first. You're the plaintiff. Any questions, ma'am? Okay, Timothy, any questions, sir?
So this case is just setting up for a court case then?
That's right. It's setting up for a hearing now.
Okay, so do I just state to you the evidence I want to present, or I just email it to you?
That if you have evidence, what you will do is well, it depends. Now, the next question is, do you want to do this by Zoom or do you want to do it in person?
I would rather do it by Zoom.
Okay, we can do it by Zoom. Then you need to mail it to me 1 week prior to the hearing. And you
Okay.
also need to mail Ms. Gonzalez-Dean copies of what you're going to present too. And
Okay.
Ms. Gonzalez-Dean, if there's any evidence that you want to present, you need to email it to him. And again, it doesn't get entered till we have a witness on the witness stand. And that witness can be you. You know, here's the pictures I took of me with my child. See how well we get along. Here's the evidence of a hospital thing that an incident occurred with the child on the other person's parenting time, and I believe they were at fault for not watching the kid or supervising the kid well enough. Something like that.
Quick question. You said email
Sure.
and mail. Which one did you want?
If you're going to email exhibits and stuff, just email them to my clerk.
Okay, yeah, you just said both, so I was a little confused. Sorry.
Well, there you have both issues. You have kind of both there. You can email it, you can mail it to the court, or you can email it to my clerk.
Okay, thank you.
All right, but you also have to email it to the other side too, and she has to do the same.
Okay.
Miss LeVay, do you have their emails by chance?
I believe so, but I can triple check.
I know we have his. I don't know if we have hers.
Let me see.
Claire, I believe I have Claire's email. Has it changed from?
Okay.
Email?
Yeah, you have Claire's. Email it to Claire. Claire can email it to my clerk, Rebecca.
No, I do have both emails.
Okay,
I emailed both of them for today's motion, so they should have emails.
Yeah,
it.
so that's the email that you'll do. She'll have to send a confirming email. We will mail out the notice. It's going to be at least 60 days before the trial happens, because I'm generally, if I have an opening, we may get you in sooner. But I highly suggest you consult an attorney because you're swimming in deep waters at this point. Okay? All right, good luck to both of you. Take care. It was nice meeting you. And we'll do it by Zoom. All right.
All right. One last question, sir.
Sure.
So she's gonna email me Shayna's email because I don't have it.
Yeah, we're gonna have to. Shayna, we'll have to give him that so that you get the exhibits as well.
All right.
You should have all my information as I've received emails from him in the past, but I can do that.
Yeah. Again, you never know. All righty. Okay.
People lose things over time, so that's why I was asking.
Pretty much. So that's why I'm not very tech savvy myself. So I can understand where somebody may have an email and think they lost it. I'm sure it's in an email chain somewhere, but they would have to hunt it down. So getting it current is probably a good idea. All righty. Have a good morning, everybody. Take care. I'll see you in a little while. All right.
Bye.
Okay. Next, Miss Ballast.
Morning.
Good morning. And we did not preserve proofs in this case, or did we? Because you put the settlement on the record. Yeah, we did. That's what I thought, because we put settlement on the record.
Maybe you know better.
Well, we'll ask Mr. Hewitt, because normally what? What's wrong?
I lost my audio.
Oh, we can still hear you.
Okay, but I can't hear you.
That's a problem.
It should be 1 second. Oh,
Randall, can you unmute, please? All right, Randall. Miss LeVay, can you check the record?
Okay, I'm going to log out and log back in.
Okay. Miss LeVay, can you check the record while we're doing
Very
this?
sorry.
Yes,
That's
I
okay.
can.
Because if I did the settlement, it would be very odd for me not to take proofs.
There we go. Now
Mr.
I can
Hewitt,
see.
welcome. Don't worry, we lost your attorney. She lost sound.
I heard. I
Okay.
could hear.
Yeah, we could hear her. She just obviously couldn't hear us. So
Yes, referee proofs were preserved on
that's
June 4.
June 4th. Okay, so the only thing we're here for is to sign this document. And Natasha is not present, correct?
That is correct.
Okay. So this will be a quick motion once we bring back the attorney. Okay, are you back? Did you connect? You're back. You're back. All righty. We are perfect. All right, we are here in the matter of Hewitt versus Hewitt.
Oh no,
case.
I lost you again. I'm gonna try my phone. Okay.
Sign language?
Gross.
It's so super gross.
Right.
The fun part is that we can actually hear her. Like, okay, Nancy, don't say anything you don't want us to hear. How's that?
I don't think she realizes the computer's.
Okay, now you're on twice. Okay.
1 second. I'll get out.
Okay, can you hear us?
Yes.
Perfect. All right, let's try this again. Take 2. All right, we're here in the matter of Hewitt versus Hewitt. This is a motion to enter a judgment of divorce based upon a settlement that was placed on the record and proofs were preserved on June 4th. For some odd reason, I did not mark the settlement conference statement that we placed the settlement on the record, so that's my bad. But I will amend that at this point just to confirm. And this comports with the settlement that was placed on the record. The other side is not here to object. Therefore, motion granted. We'll get this signed and get it processed and get it to your office, Ms. Ballas, so that you may process it accordingly.
I would be more than happy to do that. Thank you so much.
No
You
problem.
noticed earlier that proofs had not been taken.
What? No,
Did you
proofs
know-
were taken.
Proofs were taken.
Yeah. If you're in my courtroom and you put a settlement on the record, I will take proofs.
That's right. Okay.
So
We're all
yeah, that's why I'm like, there's no way I didn't preserve proofs. And my clerk just checked it on court view. It is appropriately marked in court view that the settlement was placed on the record and that proofs were preserved.
fantastic.
All righty.
All right.
So at least my clerk got it right. My handwriting did not.
That happens. Okay.
Yeah. All right. Take care, everybody. Have a good morning.
Okay.
Okay. And comply with. Give me a second. They set up a system in which it's not easy to do. The court must sign, pursuant to statute, any order that the parties agree on, especially concerning parenting time. The problem is that sometimes the parties come up with issues and things that don't seem to work. And the court has no way of doing anything because it's not something the court would have ordered in the first place. So it looks like you guys are still having problems getting the parenting time done. Ma'am, you're now asking for him to do the parenting time, and he's basically saying, look, she's done everything she can to stop it and says the kid doesn't even want to see me. So I don't even know how to help you two at this point. Again, I can enforce the orders. I have no idea how.
May I, Your Honor?
Sure.
The defendant has, via text, in violation of what you requested, he's dumped every part of the order he put in, burdening. He's chosen not to follow it each time.
Okay,
that
then.
we prepare. He sent her a text after you told him not to, and dumped every remaining component of the order and said he did not want her to come.
All right. In that case, then why are we here? You didn't want her to go. So why are we here? He basically got fed up and said, look, if you're going to keep stalling this and keep telling me the kid doesn't want to come, he basically contacted her and said, look, I'm not going to follow through. It doesn't seem you want to be here.
I never told him she didn't want to come.
You've told this court that she didn't want to come.
I said that.
Yeah, you did.
I said that at the very first hearing, and I asked him to talk to his daughter. He does not call her. He does not reach out to her. He has her blocked. She's dealing with a lot of psychological components. She's struggling. I let him know that as well.
Right.
It's taken a psychological toll. I did tell her that she does need to go. And she lost out on income. She lost out on everything. And you explicitly told him that he should have called a hearing if he wanted to pull that back. And he did not. And it put me in a position, if I don't show up, I have to pay $3,000. So we have to.
Did I not hold you harmless for spring break because he made choices that interfered itself? The court's not stupid. I mean, I would hold you, and I can only hold you in contempt or charge you in the event you purposefully violate the order. You have to purposely violate it. The last showing did not show you purposely did it. You didn't. You know, at this point, my problem becomes I can't force people to do parenting time. And you don't want to force someone to do parenting time because do you really want to hand them a child that's, you know, doesn't want to go, or that he doesn't want to have with him because she's going to be a handful because she doesn't want to be there? I can't fault somebody for doing that too.
She's very kind and respectful, and she always has been. He has not.
But again, you guys set up this order, and it's in such a format that I'm not sure what to do to. All I can do is say I'll help enforce it, but I'm not sure what to do about it. I might not have ever entered an order like this. But I don't have the choice. You guys chose to sign this. This was an agreement between the two of you. So, sir, you're basically, it looks like from your response, you're kind of throwing up your hands and saying, look, she's told me all along the kid doesn't want to go. I'm not going to force this.
Yes, Your Honor. May I speak, Your Honor?
Yeah.
Yeah, and so the same thing as she's expressed time and time, not wanting to be here because of safety and concerns. So what I offered instead, Your Honor, I said, okay, well, I'll come visit you if that's okay. And then I heard that she was no longer or consenting or didn't want to consent or welcome a visit. So at this point in time, Your Honor, I am fine.
I did not say that.
Okay. All right. I didn't say you did. He didn't say you did. It sounds like the daughter told him.
So I was in response to my daughter's response to that on July 6th, when I sent her a message on June 25th about asking about a visit, responded back, she doesn't consent. And the words consent are really strong.
Okay. Right. Yeah.
So I'm willing to vacate
what I will do is I'll leave them in place just in case. But Mr. Moore, try to work on your relationship with your daughter and see what happens in the future.
Please.
That's the best I can do. I'm not going to abrogate what you guys agreed to. If at some point in time in the future it becomes available, great. We only have a couple more years left anyway, right?
Should be 18 and 13 months, Your Honor.
Yeah, so I mean, you don't have that much. And on a 17-year-old, the court can't force to do anything anyway because the police are not going to make it happen.
Right.
But what I would say is just continue to open the door and leave the door open and contact her and see if you ever can establish a relationship. She may find that she needs her father when college hits. You know, something about assistance with money, something about assistance with other issues with college that sometimes children need both parents for. Sometimes that opens doors that otherwise the kid didn't even realize they needed opened or that a door existed.
Yeah, she loves her father. She's just
good. Yeah, and
well,
you know, the problem is, you know, once you put this kind of distance between parents and kids, it almost becomes impossible. Somebody always loses, and generally it's
this was this way in Michigan. And
yeah, well, I think you've said that before. You know, I've only had the case since 2019. We're dealing with a 17-year-old. So I've only dealt with it a few years. But, you know, I know those arguments have gone all along. And he said, no, that's not the way it was. Both of you have had conflicting arguments this entire time. So at this point in time, that would be the direction of the court. I'm not holding anybody in contempt. I'm not forcing anything here. And I wish you all well, and I hope she gets the help she needs. And sir, just leave the door open, continue to contact her, and maybe she will, especially if she's in counseling, that door may open because she may.
I suggested joint counseling.
And you know, if the counselor is willing to talk with the father and the daughter, great. he should know who the counselor is in any event. He does have.
She doesn't have one. We don't have the money to do it right now.
Okay. Okay. All righty. I wish you both well. You guys have frustrated the heck out of me. I've tried to help. I've heard the conflicting arguments. I've tried to get you through it as best as possible, and they've gone on and on. But take care of this young lady. She deserves that.
Thank you.
Take care. Good luck.
Thank you, Yana.
Thank you.
Thank you.
At this point, I think the motion would be listed as denied, but yeah. All righty. Take care, everybody. Good luck.
I know, I was wondering the same thing.
That was for you, not for them.
Yeah, thank you.
That was for you to be able to mark it in the computer.
Thank you. Okay, we can do.
Because they really did not ask for much of anything. Again, they come in wanting to throw 4, 5, and 10 pages of jibes, single space typed at each other, hard to read, and then they want me to try and vet it out. And it's like, guys, I would have probably never agreed to sign this order if the law didn't mandate I do so. So,
Good morning,
in any
Ms.
event,
Ortega.
did you connect?
We can do.
Good morning, Your Honor.
All righty. And is Mr. Buggs with you by chance, or?
He's not. I don't believe he's going to be able to appear today. He's out of the country. Was
Okay.
hoping that he'd be able to join.
Well, it's like the time zones might be a problem. Watch him show up. Watch him show up later. I've had that happen.
I was hoping to see the leather suit coat today.
I apologize. I took it into work. As one of my coworkers indicated, I can wear it into juvenile hearings and officially call the kids Utes. For those of you who have watched My Cousin Vinny. But I did wear it around, and it got some big smiles around the courthouse. But in any on this, it just looks like it's shiny. So, but in any event, Ms. Hayes, welcome.
Good morning, Your Honor.
So that who's Regina Dix?
That's Regina Archie. Her married last name is Dix.
Okay, that's true. And Ms. Hayes, who are you here on behalf of?
On behalf of Miss Dix.
You're here on behalf of Ms. Dix. Okay. I'm sorry, I didn't have a response or anything from you, so I was just trying to figure out. I should have guessed, right? Let me guess, you filed it in the past day or two?
I did file it, yes.
As long as the other side had.
Ago, so.
You did file it a week ago, huh? I should have had it then. Oh,
Yes,
no, I did have it. Never mind.
Okay, good.
Forgive me. I did read it too, by the way. I was reading my notes, of which I have several on this one, so. Ms. Dix, did you connect?
Yes, I did. Sorry.
Okay. Welcome to both of you. All righty, we are here in the matter of Archie versus Buggs. Ms. Ortega, is there anything you'd like to add to your motion?
Yes, thank you, Your Honor. As I stated previous, just going on the record, my client is not here today. He's in a part of a country where he can't appear by Zoom. He was going to try. However, we didn't want to delay this motion for a different day because we've already delayed long enough, thinking that we were going to be discussing potential settlement. But after we adjourned our hearing, it was crickets for a long time until we filed this notice of hearing.
It's okay.
You said you have several notes on this, so I'm not going to belabor my argument, but just as noted, my client was, and I'm going first on the recommendation. I want to make sure that the court received our motion regarding custody and parenting time as well. When I look at the register of actions, it just shows an objection hearing today. So I wanted to make sure.
No, I've got both on my docket. That's why I've got several pages of well, not several pages. I've got more notes on this case than some of the other cases.
All right. Thank you, Your Honor.
Because I had to do some research on this one myself.
Okay. My client did not receive, while it may have been emailed, he did not receive the actual report and recommendation. The court knows that he filed his objection delayed. He actually filed objection after receiving by mail the signed order. And so that I'm requesting that either there's leave to allow extension on that objection, or you treat the objection as a motion for reconsideration after that order. So my understanding, in the really big thing we're arguing, is the number of overnights on that order. My understanding that Ms. Dix does not deny that he does exercise a lot more than 60 overnights a year. We are we did an average of 120. My client believes that it's more than that, but we think 120 is fair. So on that, we're asking the court to amend that order, utilizing the same information except for the overnights to be adjusted to 120 and that to backdate to the start of that order. And then for our motion for custody and parenting time, this is court. This is a similar to a Sims versus Verbrugge situation where there is no joint or there's no legal custody in any of the orders yet. So we're asking for joint legal custody. And then as far as physical custody, it was just a default judgment, no best interest factors were ever considered, no evidence as to that. And what has happened is primarily the parties have been able to work together for several years. Right. And so there really was no need to litigate those issues. My client was kind of hinging on promises that there would be increase in time as the child got older. Those just kept getting delayed and delayed and delayed. And so, and then after this at front of the court order, the 60 overnights are there. And then the realization that, well, there really is no order for parenting time. Then we started getting, or my client started getting, well, no's, you can't have her, we're not going to do this anymore type situation. And then the parties between themselves had talked about, okay, we understood there to be an agreement to a step-up schedule to like a shared parenting time 50-50, and then that would be retracted, then it would be promised again. And so I don't really believe that there is an issue with the parties sharing joint legal and joint physical custody. However, at this time, clearly there's an objection to it legally. And so we would ask the court to send the issue to the front of the court on custody parenting time and then child support review in the event that there is an increase above the 120 overnights. My client has participated in schooling. He has participated in conferences. He has participated in decisions for the child. The one thing he hasn't participated in is concerning is that Ms. Dix enrolled the child in counseling and she won't share the information. Even through counsel, I still have not received the information for the counselor. And so we believe that to be relatively new. We would like that information. And then I believe that the Michigan law allows us to enter a temporary order today based on joint legal custody and a parenting time schedule on a temporary basis because there is none right now. So on a temporary basis, we're asking for the remainder of the summer to be week on, week off, except for any agreed upon vacations they've already agreed on. Last summer, my client had the child for the majority of the summer. So this is not something new to them.
When is he coming back from wherever he's at?
I believe next week, Your Honor.
Okay.
So aside from that, and then when school starts, because we don't believe, obviously, the front of the court's not going to be done, we're asking for alternating weekends, again, on a temporary basis from Friday after school till Monday morning, and then every Wednesday overnight, which I don't believe goes all the way to a joint legal or joint physical situation. And then alternating holidays, because it seems as though, Ms. Dix, now that she knows, hey, there's no actual order, she's been getting fuzzy, so.
All right, Ms. Hayes, anything you'd like to add?
Thank you, Your Honor. First, I have no objection to the court either treating this as an objection properly filed within the time frame or a reconsideration. I think what Ms. Ortega outlined for the court as far as the legal custody not being addressed, we're not objecting to that being addressed, but we would, as noted in our response, just say that Ms. Dix has, for the majority of her child's life, exercise that legal custody. As far as the physical custody, again, as Ms. Ortega outlined, it was by default. We have no objection to the court looking at that. However, we don't think it's appropriate for there to be a joint physical situation. Very open to more parenting time. I think Ms. Dix's concern is really that the father is working with the child to develop that relationship. She understands that the child needs both parents and has encouraged the other party to, attend counseling with the child so that they can work on building that relationship and making the child feel more comfortable with it. I think the proposed modification to kind of a week on, week off is kind of drastic for her. And so we'd ask something to be graduated. I know the proposed schedule that Ms. Ortega just outlined isn't quite the week on, week off. We'd asked for whatever increase in parenting time to look at what is actually best for the child, so it doesn't completely disrupt the stability in her life. So Ms. Dix is very open to that and encouraging that relationship. So I do think it is appropriate to refer that to a friend of the court. I think the 120 overnights is a little bit high for what has actually been exercised. I think it's probably somewhere between 79 to 90-ish annually. But as Ms. Ortega outlined, obviously, if that changes with any type of parenting time order, the child support order should be modified to reflect that. So we would defer to the court as far as the next step.
Yeah, just threw out my notes on half of the stuff on the child support order, since both parties are agreeing that could be looked at. But that's what I spent about a half hour researching yesterday, was the child support order. So never mind. All right. But it's always grateful to have somebody. So in other words, I would have the child support, because I will send this to the front of the court, and I will have the child support reviewed all the way back to November 1st. That way it takes care of the request of both parties. Under Sims versus Verbrugge, there is legal custody here. The legal custody is statutory. 722.02, a child born out of wedlock has only one parent, and that's the mother, thus automatically giving the mother sole legal and sole physical custody. Sims versus Verbrugge is a case out of Kent County due to this exact order from the prosecutor. This is what it was all based on. The prosecutor by statute can only deal with child support. They're here generally on behalf of DHHS, and the state wants to collect its share of the child support. That's the only reason for those orders. They have no authority to deal with parenting time, and they have no authority to deal with legal custody. The only reason that they put in physical custody, and it is ordered, default or otherwise, it is ordered under Sims versus Verbrugge itself, that the court has already made a determination as to custody. And the reason for that is, under federal law, you have to have custody outlines so that the person can receive aid, because the only person who can receive aid is a person that has custody. Thus, that's why the prosecutor has to put that in there. So yes, custody has already been determined, but as you both know, in Michigan, custody is a word. I can grant her physical custody and grant him 300 overnights a year. What matters is parenting time. Pursuant to Sims versus Verbrugge, legal custody can be looked at. I don't need a change of circumstance, so I will send this to the front of the court for legal, parenting time, and child support. Normally, I'd tell you that the older the kid is, the harder that legal custody is. This is a 2010 case. We're dealing with a 15-year-old. We're not talking about a 2 or 3-year-old. Normally over time, the established environments of legal and physical established with one parent or the other. If he's been involved as much as he says, and been involved with the school, and been involved with the physicians and doctors, then he may, because the other step is you have to determine, since change of circumstance is thrown out the window by the case law, because of the way this was entered, and statutory is the only way she has legal, the court doesn't need a change of circumstance to then look at it for a court order. However, you still have to overcome a custodial environment. So if the front of the court finds that there is a legal custodial environment with mother, he would need clear and convincing evidence to overcome that. But Ms. Hayes, she does have the right. You indicated that he knows the counselor, or they've asked him to be involved. Ms. Ortega is of the opinion that they don't know it. I would ask that information be exchanged, because pursuant to the health code, both parties have the right, as long as they are legal parents, whether they have legal custody or not, they have the right to access any medical or school issue. They have the right to contact, they just don't have the right to make any decisions. But they have the right to have knowledge of it and to contact those professionals. So that's pursuant to law in Michigan, that he is the legal father. He gets that right. He needs to know who the counselor is, and he has the right to make contact. This is a 15-year-old. I'm not ordering any temporary nothing. You guys have been doing this for 15 years. You'll continue to do it. I'm not going to, in 10 minutes, jump into your case and then give an order that I have no idea if it's right or wrong for the kid. Week on, week off may sound great, but I don't know. Does she do sports? Does she do anything during the summer? How far apart do the parties live? Would he be able to make that happen? These are things I do not know. Therefore, I'm not ordering something that's going to affect this child's life right now without all the information that I would absolutely need to make that decision. And heck, I've had 5-day hearings and I don't get enough, let alone a 10-minute argument by attorneys arguing on behalf of their clients. So I will send this to FOC for legal, parenting time, and child support backdated to 11/1 of 23. That way he can make the argument. As you know, up to 70 overnights a year, it does not impact child support. It takes to about 121 overnights to start impacting child support, and we'll see. You know, I don't know how far apart the parties live. I don't know what the child's schedule is, and she's 15. We're talking about interference soon with jobs and boyfriends, both of which can be problematic for both parties. Good
Your
luck.
Honor, if I may,
Sure.
I don't hear any objection or anything to the contrary that my client hasn't been involved. He's had the child overnights and weeknights.
I agree. He should, but I'm going to say continue doing what he's been doing. I'm not sure what that is.
Okay, and that is
Now,
fine.
I'm ordering
My
her
concern
because
is
Miss Dix, and I hope somebody has kept calendars about who's done what and when. It would be nice to know what the history is here. But I would highly encourage you to continue what you've been doing and allowing the reasonable parenting time that is already ordered. It is ordered, reasonable as agreed. Sounds like for 15 years they've had some agreements and have done pretty well. And it sounds like the child is doing well. I'm not hearing anybody say the child's not doing well. Maybe some counseling due to being a teenager. God help us all. We all got through it though, right? All right, so we'll get her through it too. But I would encourage Ms. Dix to encourage that relationship. Don't withhold the child, because that is one of the factors. If you withhold, that can be held against you. So, and if you give him time and he does not exercise it, that can be held against him. Held against him. Let me do proper English here. But in any event, just continue to do what you've been doing. Do it in the best interest of this child. Make sure that both parties, you've got the rest of high school and prom and all these other things coming up that everybody needs to cooperate a little bit better. You've been cooperating for 15 years. I'm not jumping into your life right now and doing something that may hurt instead of help. Okay. So I will send this to the front of the court. It'll be a $150 charge for each party. So I'm not going to waive the charge because they're both represented by attorneys. And then hopefully that'll help. You might be able to get through this easily. They finish 80% of the cases. Luckily, the 80 to 85%, 10 to 15% come back and need court hearings. But you've got two good attorneys on this, Ms. Dix. The father is represented well, and so are you. So hopefully they'll get you through this, and the next 2.5 years, that's all we've got.
Yes.
All righty.
Yes.
So take care of yourself, and I'll send that to the front of the court, and I'll do the recommendation order.
Okay.
Thank you.
All right.
Should I prepare an order, Your Honor, regarding the information on the counselor and then the retroactivity of the child support?
If you wish, I'm going to put it on the recommendation that child support is supposed to start on 11/1. But if you want to back it up, you're more than welcome to.
All right.
I have no problem with suspenders and bootstraps.
I don't think it'll be an issue. I'll contact Ms. Hay.
It probably won't be, but
well to make sure these things happen.
Nice to see all of you. You have a good morning.
Thank you.
Good luck with the rest of the summer, Miss Dix, and make sure that.
Thank you.
No problem. And maybe you could talk him into taking her wherever he's going next time.
Well, Well, we'll address all of those things.
Yeah,
There's a lot of things that have been mentioned that I just have not, spoken on it. My attorney has done a very good job speaking for me, but there are a lot of concerns.
Well, that's why I'm sending it to the front of the court, and that's why I don't change anything. Because what I also try to do is prevent the mudslinging. I get blamed a lot for talking a lot, and part of it is to help settle the clients, let them know I'm listening and I'm reviewing what they've said, but I'm also preventing them from mudslinging at each other, because once you say something, you can't put it back in your mouth.
Absolutely.
And the other side has heard it and it reverberates in their head.
Yeah.
So if I can prevent the two of you from doing something like that, I found that actually assists the cases.
Yeah, absolutely. And I'm not interested in doing that. I'm interested
No, that's okay.
Stating the facts and, the best interests of my daughter. And as you stated, she is 15. And, so it's quite interesting that we're here regarding child support and parenting time and how those things kind of, but thank you very much.
Have a good morning. Good luck. And they'll be contacting you in the next week or two.
Okay. Thank you.
Take care, everybody. Stay safe.
You too. Bye.
Kendra, I'll try to remember to wear the leather jacket the next hearing we have with you. All right, next.
Miranda
Morning.
versus Solano.
Good morning, Mrs. Mlazi. Welcome.
Thank you.
Is Mr. Bracey here? I would assume he's here.
He is. He's just
Okay.
taking a moment.
Taking a while. Okay. Sometimes that happens. Not quite. Mr. Bracey, did you connect?
I did.
All right. Welcome, everybody. We are here in the matter of Mlazi versus Bracey. I have read your motion, or I've read your objection, Mr. Bracey. I've also read Ms. Mlazi's response. And Ms. Mlazi, I might agree with you that he went into a lot on his objection about how he feels mistreated, and that's fine. Bottom line, he objected. So at this stage in the proceeding, what happens is you're granted a hearing, okay? And it comes with this warning. You know, normally we get through the front of the court because they can hear hearsay, they can hear the things that sometimes is not easy for both of you to enter into court. What you have to understand is the hearing, you'll be treated as attorneys, both of you. You'll be giving an opening statement, which welcome back to English class in high school. That's the bullet points of your essay, what you're going to try and show to the court, what each paragraph is going to be about. It's not testimony because you will not be sworn in for opening statements. Once opening statements are done and you tell the court what you believe you're going to be able to prove to them, you call witnesses. Once your evidence comes into court through a witness on the witness stand, you don't get to hand the court a ton of paper and think that the court's going to read it. The court will not. The court only reads exhibits that come through into the court as evidence through a witness on the witness stand. In other words, the grades come in. Maybe, Mr. Bracey, you put yourself on the stand, because you could put yourself on the stand, you can put the other party on the stand as well, or anyone that you believe would be pertinent. If you need help in subpoenaing any witnesses, the Legal Assistance Center on the 5th floor of the courthouse can help you issue a subpoena for that person to show up at the hearing. But once they're on the stand, you hand them the piece of paper, they identify it, it's marked as an exhibit, and then the court makes a determination on whether it's entered or not. And that's how the court sees paperwork. Otherwise, the court hears testimony from each of you under oath and any of all of your witnesses. So what you're going to try and prove to the court is what's in the best interest of this child. Okay. In doing so, that includes, you know, I would look up the 12 best interest factors. They're online. That's how the court looks at things. We have one child here who is, let's see, about what, 16? How old's the child?
She's 16.
16? Okay. Sorry, I've dealt with a few children this morning of all varying ages, so I don't have all of them memorized. But at this stage, the trial will be set for you. It's going to be with the judge at this point, and it's going to be in person or by Zoom. She'll make that determination. So I can't tell her what to do. So my only thing with each of you is, Mr. Bracey, you're the objecting party. Any questions, sir?
Yeah, so the information I take in, how do, and you say that the judge make a determination off of this information. Well, the information that's being taken is all from basically from her perspective, Sarah's perspective.
None of that's going to come into play. You are now going to have a court hearing about this.
Okay.
If you have some cross-examination that you have, great, but you're going to be given the opportunity to present your witnesses and what you believe to be in the best interest of this 16-year-old. She will then cross-examine your witnesses. Once you're done presenting all of your witnesses, she will then present her witnesses and you will be able to cross-examine them. Like I said, you'll be treated like attorneys. So you're walking into court as straight on. It depends on either one of you, whether you call the front of the court and bring them as a witness to enter the front of the court recommendation or not. I've had cases where people don't enter the front of the court recommendation at all, and it doesn't have any bearing on the case.
Yeah, because at this point, I just don't feel confident in them, but you know.
Well, and again, if she calls the front of the court as a witness, you will be able to cross-examine the front of the court.
Okay.
Okay. That's dependent. It's a kind of a poor way of putting it, but the court provides the place for the party. You provide the party goers. The court doesn't determine witnesses. There's only been once or twice in 18 years that I've called a witness that I've called because the parties didn't give me anything that I needed to make a decision, so I had to call some witnesses.
Yeah, right.
Okay. That happens very, very rarely, but for the most part, all the witnesses are called. This is a state-driven case, just as the other one was from 2013. In this case, again, neither one of you brought this case. So this was brought by the state of Michigan through Kent County's prosecutor's office through Mr. Hahn. So in the case of Mr. Hahn proceed, and then we'll deal with your other case as well. And I'll let Mr. Hahn stick around for that one. I don't know how much she really wants to be involved in that one because it's a very old case. So Mr. Hahn, you may proceed on the current motion.
Thank you, Your Honor. The 2023 case was filed on November 29th and service was proper on December 18th of 2023. We did receive a response from the defendant on January 16th of 2024 requesting genetic testing. Genetic testing was ordered, genetic testing order, was entered on February 1st of 2024. While it did take some time to get the parties sampled, we were able to get those parties sampled as well as the child. It was determined that the defendant is the biological father. Sorry.
Please proceed, Mr. Hahn.
Sorry, for the minor child in this matter. Notably, Your Honor, as you indicated, the parties do have a 2013 case for 2 other children. I am requesting that that case be consolidated into this one. A pre-hearing conference in the 2023 case was held with both parties via phone on July 3rd. I did collect their information. It is in front of you as proposed for the judgment of paternity and child support order. Now, it was brought to my attention that one of the children is biologically not the defendant's child. However, there was the 2013 case did establish paternity for that child. And as such, the child support order in this matter pertains to all 3 of the children, since legally that child is the defendant's, although biologically may not be. I am requesting that the judgment of paternity and child support order be entered today. The effective date, notably, is July 1st of 2024. Should the court choose to change that, I'll leave it to the court's discretion given the circumstances in this matter. But I do believe the documentation is appropriate for entry today, Your Honor. And if the court would like me to weigh in on the 2013 case, I'd be more than happy to do so in the best way I can.
If you stick around, I may have you do so. Ms. Johnson, on the 2023 case, any questions?
No. I do have a question about the calculation result.
Okay, well, that's the question for what's the question?
So it says he'll pay $14.60 a month, but then it says he'll be paying me $11 on the 4th page.
Those are the birth expenses. He's not paying. Wait, where do you see $11?
It says calculation results, and then it says Thomas is paying Kimberly $14.60 a month, and then it says support amount based on known actual income of parents. Thomas paying Kimberly Johnson $11. It's in the little box at the end.
Your Honor, I can comment on that.
Yeah, please do.
The little box on the end. Now, I've not received formal training on this little box at the end of our calculations after a few years of doing this, or a couple of years, however long I've been doing this. I have gathered that when an individual's potential income is used, calculation will look at what we imputed the individual to, and that's where the $14.60 a month comes from. Now, because his actual income is not the potential income we've given him, essentially left him at 0, that's how much it would have been.
Okay. I just wanted to know.
Multiple individuals question that exact same thing. I apologize for the confusion. It's just the way that the formula is run on our side.
Okay, that's all I needed.
I was going to say, I've never heard an explanation of that one either. I've always ignored it because it doesn't make any sense.
Again, I could be wrong, but that is my 5 cents on that. That's what makes sense to me. That's
because it says actual income of 0.
Yeah,
he would pay 11.
Okay.
Mr. Johnson or Mr. Chandler, what's your input on this one? I mean,
$14.60 just sounds a little expensive to me.
Well, what is your actual income? What are you earning?
I'm not employed right now.
Okay, when were you last employed?
In May.
And what did you do?
I was a truck driver. But
what were you earning?
I was getting 50 cents a mile.
And how many miles did you normally travel?
Every week my expectations was around 3,000 miles a week, but I never reached that.
So how much did you normally travel? And
maybe like 1,800.
Okay, at 50 cents a mile, you would have gotten as a contractor?
No, W-2.
So you were a W-2 employee. So they took taxes out of the...
Yes.
So you were earning about $78,000 a year, technically.
No, I only worked. I barely just got my CDL a few months ago.
And why did you lose this job?
Because FOC continues to suspend my license. My license is my job. So if they continue to suspend my license, then when companies find out, I have to have an active license for 6 months before they consider anybody to give me another job.
So we're basically tying his hands, Mr. Hahn?
Your Honor, during the pre-hearing conference, I did ask about his income. He did inform me of the 50 cents a mile at 3,000 miles a week, which is what I used. However, when I asked him why he no longer worked there, he informed me that, and I'm going to read my notes, he left for a better opportunity. So he did not indicate that he had any concerns regarding front of the court suspending his license. He said he left for a better opportunity.
Yes, that is true, but that's just my professional answer.
All right. I'm going to hold him at $1,000 a week instead of the 1,500. I'm hearing testimony that he didn't, but we need to get his license reinstated. And that'll be on this case.
Your Honor, would you like that as W-2 or 1099?
W-2. Because that was his potential, not his actual. Let's get him on what his actual was, and I'll hold him to what a job was that he walked away from.
Another job will not consider me.
Yeah, I understand. When did they say? Okay, when did they state? I'll deal with that in a minute. When did they take away your CDL?
Well, the state of Texas have not taken away my CDL, but other jobs, when I apply for more jobs, they do a federal background on my driving record, and when they do that, they see that my license has been suspended in Michigan because they run everywhere that I had a license.
So your CDL is through the state of Texas?
Yes. But when it comes to applying for other jobs, I'm applying for jobs that the terminals reside.
Is it currently suspended in Michigan?
Yes.
And that's due to child support?
I believe so. I never found out why, but every time they send me my driving record, it says that Michigan suspends my license. And I know FOC always suspends my license every month or two.
Great. That helps not. All right. I'm going to combine this decision then. Ms. Johnson, a motion was filed concerning the actual father of your child. There's indication that you knew in 2012 that Mr. Chandler was not the father of this child?
Yes. And me and his actual father, his biological father, went to court. I don't know what month it is. I don't know if you guys can look that up, but they told me that Thomas needed to file in writing to petition paternity by July of that year. Because I don't know, it was weird. Every time I went to court, I got different answers. It's been horrible trying to get this situated.
All right. Do you guys have any current DNA tests that show?
So we got one, and it was a Walgreens test, and they couldn't use that.
So that's not right. All right, you guys just went through DNA diagnostics. So they have his genetic material. What they need is Thomas Chandler's diagnostic material.
Yes.
I'm going to grant a DNA order because it seems like you two are in agreement that he is not the father.
Yes.
And that you would prefer to have the child be listed for his real father on the birth certificate.
Yes, that's correct. Yes.
Because normally what I'm jumping through a couple of hoops with is that a judge denied this in 2018 because no DNA was given to them. I need new DNA testing that shows that he is not. So what I'm going to do is I'm going to have a hearing on all of this instead of getting child support on 3 children, Mr. Hahn, currently on an income that he is not expecting. And I'm inviting the friend of the court and you to that hearing because I want to work out something, because if we're tying his hands and this man can't work, that's not helping the kids at all. They're getting no money. I can order $1,500 to $3,000 a month, but if there's no employer, all we're doing is spiraling him into debt that he can never pay, and that will keep round robining without him getting a driver's license that's usable.
Right.
So I need a cohesive and just comprehensive motion on this and a hearing on this. But I need Ms. Johnson and Mr. Chandler to cooperate and get the DNA of young Junior.
I can do
Ms.
that.
Johnson, so that you understand, any affidavit of parentage signed by Duran is worthless.
Null and void. Yeah.
Yeah, it's null and void because you got to have him born out of wedlock or not have him have another legal parent.
Okay.
What I'm going to do is trigger a very little used clause in this, and that is sometimes time, even though we can only are supposed to do this within the child's 3 years of birth. My problem is we've got a child out there that you guys knew, and this entire thing, no offense, Ms. Johnson, was based on a lie. That Mr. Chandler was the father. We had jurisdiction at the time, we ordered it, but let's undo a wrong instead and try and get it right. But I need the DNA to actually show that for the file. And then we can do a calculation based more cohesively on what he can actually earn with the front of the court. And maybe I can get the front of the court and get an order that says he keeps his license.
Okay.
And we will not touch it for a year, regardless of how much is owed.
Okay, that's fine. Yep.
And that way I can also find out from them, because it's not part of the court file, how much arrearage there is here that we're going after. All right. So let's see if we can do this and make it possible to get these kids the money they deserve and the fathers they deserve.
Okay.
All righty. So I'll grant a hearing. Mr. Hahn, I'll invite you, and I'll invite Ms. Lipford as well. Oh, I'm sure. Yeah. Thank you. I heard that in between between the lines. I get it. No. Again, we're just I know. I'm kidding. Okay. Sorry. Thank you.
Your Honor, can you please clarify as to how we're doing the genetic testing in this matter?
I'm asking them. They did it through DNA diagnostic. They are going to have to get the genetic testing.
Okay.
If you don't, I'm going to have to deny any change.
Okay, I'll get it.
So I'll give you a couple months to do this. I'm reserving the child support for this case so that we get it right, and we'll do it from the beginning. So if it's 2 children, it's 2. If it's 3, it's 3.
So I get it, and then I just bring it to FOC, or do I bring
no,
it to
file
court?
it with the court. File
Okay.
with the court, send Mr. Hahn a copy as well.
Okay.
All righty.
All right. Thank you.
We'll see you soon. I'll get you the notice of that hearing as soon as possible.
Thank you, Your
Okay,
Honor. Now,
thank
will you be drafting the order?
At this point, we're just drafting an order granting a hearing. So I'm adjourning the matter on your case.
Thank you, Your Honor.
No,
And
thank you.
I have no contact for Thomas. How are we gonna?
You just had a child that you took in for DNA testing that showed Thomas was the father, right? Go back there and I'll draft a DNA order when you get that. That should help. But they already have Thomas Chandler Sr.'s DNA on file. So
Okay.
they shouldn't need that one. If they do, please contact Mr. Hahn or we'll deal with that at the hearing.
Okay.
But Mr. Chandler, I'd cooperate and see if they need any more DNA from you.
My thing is the communication with the courts and all parties involved. Just like this hearing today, I literally had to spam call the courts just to get this link to be involved in this court case.
All right. Do you live on?
Yes.
In Texas?
Yes.
That's where this will be sent to. And is your email your name at gmail.com?
Gmail,
yes.
at Gmail, yes.
We will email it to you as well.
Okay.
So I will order DNA testing for Thomas.
Okay. Thank you so much.
All righty. No problem. Thank you.
Thank you, Your Honor.
All righty. And do we have another one with you, Ms. Don? So I will let the state proceed with its motion, and then I'll ask for input from you, Elizabeth.
Thank you. I'm requesting the court enter a judgment of paternity and uniform child support order. A complaint was filed on December 20th of 2023. Defendant was served and filed an answer requesting genetic testing. That testing was completed by all parties and established that defendant is the child's biological father. He had a pre-hearing scheduled on June 17th of 2024. Only defendant participated. I explained that this case would be consolidated with the parties' other case or their other two children. And that child support for 3 children is based on the plaintiff earning $13.70 an hour, working 32 hours a week. With 365 overnights and 1 other child. And defendant earning actual income of $18 an hour, working 40 hours a week. And having 2 other children. The calculation resulted in base support of $624. $65 in ordinary medical. For a total order of $689 per month. The uninsured medical split will be 43% to plaintiff and 57% to defendant. And the effective date of the order is January 1st of 2024. Defendant is also responsible for $71 in genetic test costs, where costs are waived.
Did you say that's $700?
71.
And
Your Honor, genetic test costs do need to be added to the proposed uniform child support order.
Elizabeth, do you have it? Oh, I'm sorry. Mr. Arnold, anything further?
No, thank you.
Elizabeth, do you have anything?
Well, I wanted to clarify with the court. You said that each one of us will be having some percentage to pay regarding the child support. So I just wanted to be clear, how much should I pay and how much should he pay?
You are not paying anything. The percentage is based on your incomes for each of you. And that percentage would apply to health care that's not covered by any insurance. So part of this order takes into account any future health care needs of the child. So if the child falls in the playground and breaks their arm, and the insurance covers everything but $100, each of you would pay a percentage of that $100 based upon your actual income. That prevents all of any extraneous health care from being assigned to you only. Any other questions?
Ikijanye na divorce kwa barambwiye ngo yarayisinye ariko nta rukaratasi rugaragaza ko twa divorce icyo nacyo numvaga nshaka kugira ngo bakimfashemo.
The other question that I have is about the divorce agreement. they had told me that he already signed this agreement, but I'm not sure. And I wanted to ask the court if you can help make sure that I have the final answer for this.
This is not a divorce. This is a child support issue.
Okay.
The court knows nothing about any divorce.
None ko nabisabye bakambwira ngo bazabimbwiraho bamaze gukemura iki kibazo.
I said this earlier and they told me that they'll give me the answer after resolving the issue about the child.
The court doesn't even know that you were married.
Naho rero uwo mugabo afite urukaratasi agenda yereka abantu ngo ngende umugore we cyaka ngo bazarutane nanga bampereza urukaratasi rugaragaza ko atari umugabo wanjye.
So now the issue is this man has got a paper that he shows people, everyone, that I'm the wife, that we are married, and I would like to ask maybe if it's possible to ask him to bring this paper to me or to cancel it because I'm really worried.
Did you ever marry him, to your knowledge?
Ntabwo twasezeranye ariko hari urukaratasi bahaga abantu ngo buririreho indege. Urwo rukaratasi niyo yumvise hari umuntu uri kuntereta ararumwereka ngo ndi umugore we. Nge rero nkabura urwo nerekana ko hari umugore we.
We were not married, but there is a paper that was given to us before we took a flight to the US. So it is the same paper that he shows to the people that I'm the wife and I'm really not.
Iyo arwereka abantu rero bo bagendera kugwa rukaratasi. Ngewe bazamuha itegeko ryo kuruta nangamo kimwe bampe nanjye urwo nakwereka abantu ko ntari umugore we kuko ari unkoresha.
When he shows this paper to the people, the one that he brought when we fly, so they think, or they say that I'm the wife and I'm not. So I would like this paper to be taken away from him, or I want another paper to be given to me to testify or to show that I'm not really the wife.
Hari n'igihe arwereka abapasiteri akababwira ngo umuntu uzasezeranya umugore wanjye ngo azambona, akarwereka anavuga ngo nta muntu wemera kunsezeranya kandi mfite umugabo kandi nta n'uwo mfite.
There is also time he showed this paper to the pastors and he told them that there's no one who is allowed to marry me, and yet I'm not married. So it remained an issue.
There is nothing I can do about that in this case. You would have to file a civil case against him for lying about your marriage. This case is only about your child and child support that's owing due to that child. But at this point, I will note that he is not present. This matter was set for a hearing at 10:30. It's now 11:24. Defendant is not present, and I am going to grant the prosecutor's motion to enter this judgment of support. Have a good morning, everyone. 2308DS. Good morning. This case was brought by the state of Michigan through the Kent County Prosecutor's Office. Neither one of you asked for this case. It was mandated by law because of state aid being involved. When state aid is involved in a case, the state mandates that child support shall be set by law. The parties don't get a chance to agree, and that the state will confiscate part of the child support that's paid to reimburse the state for what they're paying for the child. So whatever I order this morning, ma'am, you're not going to get all of it. The state's going to confiscate part or all. So we'll go into your input, but I'll let the state place its motion on the record, and then I'll ask for input from each of you.
Okay. Your Honor, there was a pre-hearing conference scheduled for June 18th, 2024. The plaintiff...
I'm sorry, that was my mom. Sorry.
At that pre-hearing conference, the plaintiff only participated. The defendant failed to participate. I called him twice and he did not answer. The plaintiff earns $17.99 an hour and works 36 hours per week. I used her actual income. The defendant was working at GRPS as a janitor, earning $21.51 an hour at 40 hours per week. But the plaintiff stated that he quit his job in May of 2024. He had been working there since April of 2019. Therefore, I imputed him to his former income of $21.51 per hour at 40 hours per week. Per the plaintiff, the children do not spend overnights with the defendant, so I ran guidelines with the children spending all overnights with the plaintiff. I'm asking that the court enter the proposed judgment as well as the UCSL.
Thank you. Ms. Aguilar, what's your input?
Not sure. What input are you looking for?
Asking if you have any questions or what your input is on the order that's proposed.
I honestly don't really have anything or much to say about it.
Okay. Mr. Putnam, we're going to have you unmute so that we can get your input, sir. What is your input, sir?
My input is I was let go from my job. I didn't voluntarily quit, and
why were you let go?
I got written up too many times.
Okay, so it's through fault of your own then.
Yes, it was, but I was told that when I got let go, they told me to voluntarily quit, and it would help get my unemployment. And
Are you receiving unemployment?
No, I just got denied. I had an appeal for it last Thursday.
Well, this is the appropriate order to enter. If you get the unemployment, then you may reapply immediately, and I would suggest you do so. File a motion to have your child support reviewed, because if you're on unemployment, the presumption will go with you that the unemployment is the income that will be used for child support.
Okay.
But if you're denied, we presume that you lost your job through fault of your own, and we hold you to your former job.
Yes, sir.
All righty. So, and apply to the court. You can get the paperwork at the front of the court, and then once you change jobs, folks, a child support can be reviewed every 3 years just because of time. If you lose your job or get higher income, you may have it reviewed at that time. That's a change of circumstance. There have been times we've reviewed these things every 6 months because people's jobs keep changing. But the thing that will help you, sir, is if you get the unemployment, then you apply immediately, and we will adjust the child support to that day you apply, but we cannot adjust it until you apply. Okay? And we can only go back to the date that you apply. And sometimes it takes 2 to 3 months to adjust, which means the arrearage would then have to be corrected by the correct child support. But for now, this is the appropriate order. Okay?
Excuse me, Your Honor.
Yeah.
I have two things
Sure.
just real fast. The unemployment, I applied for it in April, and I had the appeal, and I was denied the appeal literally less than a week ago, and I was going to bring it up during here.
Right.
On top of
well, you have to, for it to help this court, you have to be accepted.
Okay, that's fine.
Yeah.
And then one more thing, I just wanted to state that the kids do stay overnight.
Okay.
Me and Julie have no issues really, but we know that the child support thing is
yeah, it's up to 70 overnights is not going to change the child support at all.
No, that's fine. I don't mind paying it. I'm just trying to get it.
Well,
clear,
it's always too much for you to pay and never enough for her to receive. And then I don't know how much she's going to receive because it depends on what state aid she's on, how much they're going to confiscate. Okay.
I completely understand that.
All right, now please do not forget to apply if you get unemployment. All right.
Okay.
I don't like getting blood out of a turnip, and right now you're kind of a turnip because we take the money from your employer, not from you. Okay.
No, of course.
All righty. Take care, ladies and gentlemen. Have a good morning. Good luck.
Thank you, Your Honor. Yep. Thank you. You too.
All right. Okay. And do we have anybody next, Miss Mlazi?
Yes, for Rice. Oh, I have to sneeze. Sorry.
Bless you.
Rice versus